what clauses legally could a lender invoke on their developer clients?
There are a litany of clauses. There's some of the obvious ones, and there's the not so obvious ones. So the mainstay of your loan agreement is split up to undertakings, representations, events of default. There are obvious ones like non-payment, insolvency, cessation of business, abandonment of site, etc. You've got the more tricky ones like MAE clauses. That's quite narrowly defined. I think it'd be quite troublesome for lenders to do that, but there's now recent academic argument that they could use that. But there are not so obvious ones, which are, so for example, you have to comply with all your insurance obligations, and you find your insurance contract. Have you kept the site adequately secured, inspected, regularly inspected, that sort of thing. So you could fall foul of some of the more less obvious things. The way that those agreements are written, they are robustly in favour of lenders, as you would expect. I think when we negotiate these documents, we get to a point where a lender says to a borrower, it's fine, we appreciate what it says in a black letter, but it's about relationships. And now you're going to find out how good those relationships are, and whether you picked a good lender or a different type of lender. And then it comes back to what Dan has said about professional, experienced, resilient lenders who know the market. And then I have to say, we've been seeing that if you picked a good lender, that it's working well. It's working well for good developers and good lenders, and they are collaborating and working well together, as Ed has said.